Good morning. Welcome to a continuation of docket number 250811. We are here for a late filed exhibits hearing. We're meeting by remote teleconference. I'm joined here, I'm presiding officer, Commissioner Holly Cheeseman. I'm joined here by Commissioner Janice Beecher. I believe Commissioner Arconti will be joining us later. We'll start with public comments. Are there any public comments? Seeing none, are there any administrative matters? Oh, I see Commissioner Karen, sorry, apologies. Any administrative matters?
Your Honor, Bert Cohen from the Office of Consumer Counsel. Um, I'm sorry that I have to bring this up at this stage, but uh, we didn't get the late filed exhibit hearing materials from Charter until I think it was after 7 o'clock on Monday night. So we didn't have a chance until yesterday to go through all those documents. Our office has been very liberal in terms of allowing, of not contesting any of the motions for protective order. I think in all the ones that were filed, I think we only raised two concerns, and both of those, both companies worked with us to alleviate our concerns and to file what was public in the public domain. Um, we have strong concerns about what is deemed to be confidential in late filed Exhibit 18. Um, the uh, documents, the sections of that exhibit that are claimed to be proprietary are not financial at all. There's no numbers, no interest rate calculations or anything like that, nor are they really commercial. They're about the pledging of um, I'm sorry, Mr. Bogan, were you talking to me?
I apologize, Mr. Cohen. I thought I was on mute.
Okay. Um, the um, the small sections of that exhibit that are claimed to be proprietary are not financial at all. Again, there's no commercially sensitive materials about interest rates, about calculations, numbers, etc. Um, uh, there are also there's footnotes about disclosure filings that are made with the Securities and Exchange Commission about the financing agreements there. And the links to those filings are included in a footnote in that exhibit. Uh, it's our strong belief that the information in that exhibit is just about what assets are pledged, what public service company assets are being pledged. That information is by statute 1643 required to be disclosed to this authority. So there's no statutory basis for those to be deemed to be confidential and proprietary, and they should be capable of being relied upon by this authority in its final decision,
All right,
including
so
quoting those. So that's our
Attorney
objection to
Cohen,
that.
okay, are you objecting specifically at the motion to protective orders and which one specifically?
Yeah, I probably should have had that, Your Honor. It's the one for LFE 18. Um, bear with me. And I apologize. I should have had that number for you. And it's not the whole protective order, it's just for the part that pertains to LFE 18. There are a number of protective orders. So it would be I believe it would be motion number 29, just as it relates to, but I could stand corrected. But it's, I'm sorry, it's motion number 32 as it pertains to LFE 18. We are not contesting LFE 3.
All right,
And
does Charter wish to respond before I discuss this further?
I do, Commissioner, and good morning. For the record, it's
morning.
David Bogan, along with Colleen Olson on behalf of Charter Communications. Mr. Cohen is right. The late filed exhibits were filed after 4 o'clock on Monday. And for that, I have apologized to him and apologized to the authority. Certainly no disrespect was intended. But, you know, even Mr. Cohen concedes that they were filed at 7 o'clock, 3 hours later. I realized the time between the filing of the late files and this morning's proceeding was rather compressed, but I can't feel that a 3-hour delay in any way prejudiced any party to this proceeding. As far as the confidential portions of, or the portions of late file 18 that were deemed to be confidential, subject to check, I believe that was consistent with the way the document was filed in Rhode Island. And so I don't believe there's any prejudice in that regard. And by the way, the unredacted versions are available to the authority and OCC. It's just that the confidential information is not on the public record. So again, no one has been prejudiced by that.
All right. Well, I think one, I'm curious as to why OCC didn't file any written objections. Two, I will take this under advisement and issue a ruling later, and parties can proceed accordingly.
I'll answer that question, Your Honor. Again, we started business early yesterday. There are two of us who will work on this docket. And it spent us the entire day to review the late filed exhibits, to evaluate them, and to figure out which ones, if any, we needed to cross-examine on, and if so, what would be the nature of that cross-examination. That would be a one-day turnaround. It would be, that is the reason why we did not. I can make a suggestion for Your Honor's consideration, and that is, as long as we can do cross on them, we can do it in a proprietary session afterwards. And we could file a motion, a written motion explaining why there is no confidential material in this particular document.
I will take your suggestion under advisement and issue a ruling later. And if you have any objections, written objections to any other motions, if you could file them accordingly, please.
Thank you.
All right. Are any other administrative matters from any of the applicants or other parties or interveners? Seeing none, do you have any new witnesses, either Attorney Bogan or Attorney Bester?
From the charter perspective, no new witnesses. We do have to have a couple of witnesses affirm the late file exhibit responses,
Right.
but no one to be sworn in today.
No one to be sworn in. And no one from Cox? No new witnesses to be sworn in?
Thank you. Zachary Bester from law firm Brown Rudnick LLP, appearing on behalf of Cox Enterprises Inc. and Cox Communications Inc. We have no new witnesses today.
All right. Would the attorneys like to ask their witnesses to adopt their testimony for this late filed exhibits, please? Attorney Bogan?
Yes, we can go first. Starting with Mr. Falk. Good morning, Mr. Falk.
Morning.
Did you oversee the preparation of certain late file exhibits submitted on behalf of Charter Communications in this proceeding?
Yes, good morning. I did. And Commissioner, it's nice to see you this morning in a virtual setting as opposed to in person. Thank you for being here and for overseeing this hearing again. Yes, Attorney Bogan.
And consistent with that, I should apologize. I should have thank the commission for its willingness to conduct today's proceeding virtually. I know folks down in DC certainly appreciated that. Do you have any changes, corrections, additions, modifications to make to any of those late file exhibits, Mr. Falk?
I don't.
Is the information contained therein true and accurate to the best of your knowledge and belief?
Yes.
And do you adopt it as your testimony in the proceeding?
Yes.
Mr. Tim. Oh, there you are. Good morning.
Good morning. Good
Did
morning.
you also have occasion to oversee the preparation of certain late file exhibit responses in this proceeding?
I did.
Do you have any changes, corrections, additions, other modifications to make to any of that information?
No, I do not.
Is the information true and accurate to the best of your knowledge and belief?
Yes, it is.
And do you adopt that as your testimony in this proceeding?
I do.
Moving to Miss Kim, good morning.
Good morning.
Did you also assist in the preparation of certain late file exhibit responses submitted on behalf of Charter?
Yes, I did.
Do you have any changes, corrections, additions, modifications to make to any of that information?
No, I do not.
And is the information true and accurate to the best of your knowledge and belief?
Yes,
And you adopt that as your testimony in this proceeding?
yes, I do.
Thank you. Commissioner Cheeseman, I would note that Mr. Murphy is also here, but he didn't have any direct involvement with regard to the late file exhibits, but he is here and able to answer certain responses as necessary. With that, the charter witnesses are available for cross-examination.
All right, Attorney Bester, would you like to ask your witnesses to adopt their testimony, please?
Yes, good morning. And again, I would also like to thank the authority for approving our requests to have the late file hearing virtually. Here with me is Curtis Stamp. Mr. Stamp, could you please state your name, title, and full business address for the record?
Yes, I'm Kurt Stamp. I'm Vice President of Government and Regulatory Affairs for Cox Enterprises, and my business address is 6205B Peachtree Dunwoody Road, Atlanta, Georgia 30328.
Did you prepare and direct the preparation of late file exhibit responses submitted on behalf of Cox in the proceeding and approve of their contents?
Yes, I did, and yes, I do.
Do you have any changes or corrections to the statements made in those late file exhibits at this time?
I do not.
Are the statements made in those late file exhibits true and accurate to the best of your knowledge and belief?
Yes, they are.
And do you adopt those late file exhibits submitted on behalf of Cox as part of your sworn testimony in this proceeding?
I do.
Thank you. Commissioner Cheeseman, the witness is available for cross-examination.
All right, thank you. And I believe first up will be the Office of the Consumer Counsel with Attorney Cohen and Rihanna Ash. So if you would like to proceed, Office of Consumer Counsel, with your cross-examination.
Thank you, Your Honor. I think Ms. Ash will get us started.
Happy to begin. Thank you, Attorney Cohen. Thank you, commissioners. My name is Rihanna Ash. I am a telecom policy advisor for the Office of Consumer Counsel. My first question is for Charter in reference to late filed Exhibit 6. Please let me know when you're there.
Yes, I'm there. Good morning, Ms.
Good
Ash.
morning. In reference to late filed Exhibit 6, Charter's response indicates that the primary cost to Charter, besides the actual labor cost of notifying the customer and reattempting to process the charge, comes from the continuation of service to the customer, while further attempts are made to represent the check. Can you please clarify or explain why the cost of continuing to provide service exceeds the cost of normal billing for the actual service, as I presume that the consumer would also be billed normally for service beyond the date that the payment was returned, as long as the service is active?
I think it would be because they are continuing to receive service without us receiving payment. And payment is associated with the services that are received. So if we don't receive payment for those services after the appropriate time period, that than a cost of that includes the cost to continue to provide service to a customer who hasn't met their financial, commitment to pay, whether it is a mistake or not. I mean, there are multiple reasons why someone might have insufficient funds that at a particular time that may or may not, it could be just a bank error, but the reality is we haven't received payment for those services, and we are continuing to pay to provide them while those funds haven't been received.
Thank you. As a follow-up question to that, is that somehow different than the late payment charge that I presume would also apply if the payment was returned and the payment wasn't received by the due date?
A late payment fee is separate from the insufficient funds fee, if that's what you're asking.
I'm sort of wondering, do they cover the same costs to the company? Are they overlapping?
Oh, I don't know the answer to that. I don't know.
Okay, thank you. Regardless of the company's position on whether it is required to comply with the relevant regulation, are the combined companies willing to commit that both companies will charge no more than $20 for a return payment fee following the close of the transaction?
I'm going to object to the question. The company's position with regard to what it's willing to offer post-transaction is set forth in its application.
Let me jump in here, Rihanna, if it's okay. I don't see where that objection has any relevance. We're now talking about the late filed exhibit and how it pertains to the applications and the approvals that the company is or is not seeking in this particular proceeding.
If I may, Commissioner Cheeseman,
Yes,
the
go ahead.
company's commitments are set forth in its application.
If you can't commit now, it's fine, but just say that.
I'm going to sustain the objection for this point. If Ms. Ash, if you could continue your questioning, please.
Charter, the next question is for you as well. Please reference late filed Exhibit 7. Can you please clarify if Charter renews the background checks as Cox indicated that they do in their response to late filed Exhibit 8?
When you say renew them, are you asking what do you mean by renew them?
I took Cox's response to mean that they rerun background checks after the initial point of hire.
I mean, I guess, Ms. Ash, the answer speaks for itself. The question that was originally posed and the late file exhibit request asked, do you perform background checks? The company has responded, yes, it performs background checks. If to the extent that you now want to go beyond that, that is beyond the scope of the late file exhibit.
Your Honor, I would disagree, and it appears that Attorney Bogan may be attempting to shorten our cross-examination, but I think we're allowed to ask a follow-up question regarding each late filed exhibit. If that's not the case, then why are we even having late filed exhibit hearings? The purpose is to get information concerning that.
I will allow the question, and if Mr. Falk doesn't know, or any of the witnesses don't know, they're simply allowed to say they don't know, and then we can move on.
I know that we require employees to update information about that's relevant to their employment. whether we conduct additional background checks on contract employees after initial background checks. I don't know the answer to that. I would ask Ms. Kim if she has any further information in response to that question.
I can only confirm what you just shared, Adam, that as it relates to employment of our employees, that we do require them to update us with any relevant incidents that may impact their eligibility for employment.
All right, Ms. Ash, do you wish to proceed?
Yes, thank you. This next question is with regards to late filed exhibit 16 and is for Cox. Unfortunately, it appears that the last part of the question, which asked, how does Cox provide acknowledgement to the customer when such a complaint is made, was not answered. Cox, can you please clarify how the company provides acknowledgement to the customer when such a complaint is made?
Yes, so I will say that we don't have a formal process for that. So I think for the most part, all of our agents are empowered to resolve the issue when they first contact the customer. So in very rare cases, does the issue not get resolved during that interaction? So there's not necessarily anything to acknowledge or send to the customer. I will say that if it is an interaction that results in, for example, moving a due date out to accommodate the customer need, they will get notification from us of the new due date, but the actual logging of a complaint, like I said, rarely happens because it's resolved during that first resolution. In the rare instance where it isn't resolved, there's, someone gets disconnected or it's got to be investigated further. The agent will notate the account, so then whoever deals with the customer going forward will have that, but there is no formal notification of your complaint being lodged or anything that's sent to the customer.
Okay, thank you for the clarification.
You're welcome.
This next question is my last before I'll turn it over to Attorney Cohen. This is for Charter in reference to late filed exhibit 19. Can you please tell us where are the 2 stores / walk-in centers in Connecticut located referenced in this response?
I don't have the addresses for those, Ms. Ash. We can certainly take that as a read-in in a few minutes. I can get access to the addresses for those 2 locations if you give a moment.
Thank you. And with that, I will turn it over to Attorney Cohen.
Okay.
Thank you,
Thank
Ms.
you,
Ash. Please proceed, Attorney Cohen.
Thank you, Your Honor. I guess my first question is to Mr. Stamp, Cox Communications, LFE 10, if you want to turn to that, sir.
I am there, sir.
As a prefatory matter, I'd like to say that is quite an impressive program. Can you talk a little bit about the Cox Behaviors program that's outlined in your in late filed exhibit?
In all honesty, I don't know that I have much more to add beyond what's in the exhibit itself, other than, I think the answer pretty much speaks for itself, and I don't have personal knowledge beyond what's in the answer itself.
Okay, but it is adopted as the training standard for both employees and contractors who work inside consumers' homes in Connecticut and in other Cox jurisdictions. Am I reading that response correctly?
That is my understanding, yes.
Okay. If you have any, if your understanding is incorrect, if you could please do that as a read-in. But I believe that's what the document said. But anyway, it's a great program. And let me ask you one final question on that. Uh, what is the likelihood that the Cox Behaviors Program will be adopted as a training standard for both employees and contractors in Connecticut?
That is a question for post-integration and probably more appropriately directed to Mr. Falk.
Okay. Mr. Falk, would you like to chime in on that?
I don't have any information today that I could share with you about that. As Mr. Stamp said, it would be a matter of consideration for integration.
Speaking for, for our concern for consumers, we think it's an excellent program, and we commend Cox, and we would
Commissioner
commend.
Cheeseman, I'm going to object. This is not a question.
All right, if you could, if the,
I'll move on, Your Honor.
thank you. Thank you very much, Attorney Cohen.
Yeah. Can I just
LFE 9 is Mr. Fox, I believe. In your response, you reference LFE 7, which states that training is provided by the contractor vendor. I guess I don't see in the response to LFE 9 and LFE 7 the overview of that type of training, particularly as it pertains to behavior that contractors receive before entering consumers' homes. Can you perhaps elaborate on that, or provide a supplemental late filed exhibit that has that detail?
Yeah, I don't have the detail of our training programs. I can tell you that we're very cognizant about the importance of our contractors and employees who are entering customers' homes being properly trained to deal in those situations. But I can't compare it to a Cox program or give you more detail about that at this time. I can, if you'd like, just interrupt for a moment. I can give you that read in on the Miss Ash's question.
And sorry to interrupt, Mr. Falk, my been remiss here. That would be read in A for this hearing.
Okay. So the two stores, one is at 14 Churchill Road, Unit B5 in Newtown, 06470. And the other location is in Willimantic, 95 Stores Road, Willimantic, 06226.
And I believe we also had a read in B, which was if I correct, Attorney Cohen, you asked if contractors were required to follow the same protocols. Please prompt me on this one.
Oh, yes, it was just basically if in the Cox Behaviors Program, I just asked whether it was the training standard for both employees and contractors who work inside consumers' homes in Connecticut.
That's what I thought. Okay, thank you. And if we can do that.
And if I may, Commissioner, I think the response itself said it was, and I think the question was, if that's not true, let us know.
All right. So
I'm double checking, but I think the answer probably speaks for itself.
Thank you. Thank you for the clarification.
Thank you.
Attorney Cohen, I'm sorry. Just in terms of our training, are you asking me something beyond the representation in response to LFE 9, where we indicate that they do receive behavioral training, including managing confrontation, harassment, or threats?
I thought that was pretty much. It seemed like a pretty bare bones response. We were certainly hoping for, because of the importance to consumers and the general public about the training that is given, we would expect that companies like Cox and Charter would both have detailed information that they want to share about the subject matter of their training.
If I may, Commissioner Cheeseman, my reading of the late file request, particularly, well, late file 7 was, do companies require background checks for contractors? That was it. Late file 9 was, do contractors receive training for how to behave when entering consumer's home? And if so, what's the overview of this training? And that's what was provided.
I believe it was like 3 or 4 words, Attorney Bogan. So we didn't see it as much of an overview. Provided very little information at all. It was at best an outline, and I'm giving Charter the opportunity to supplement that and show.
If Charter would
new
like
duty.
to enlarge on that, then fine. If not, they did reply to the gist of your request. So if they wish to expand on that, otherwise, I think we should move on, Attorney Cohen.
Okay.
I don't have any additional information. We're not all together, Chair Cheeseman, and so I will just ask more broadly, Ms. Kim, whether she has other information that she wants to share that's responsive to Attorney Cohen's question. We thought we were satisfying the request for us to provide an overview. I'm sure that's not all of the information associated with our training, or was it intended to be? I'm not here at the hearing with that additional information. But Ms. Kim, is there anything else that you would want to add that you're familiar with regard to the training that our employees or contractors going into homes receive?
Well, specific to the training of our contractors, I know we do abide by the guidelines that require us to have a train the trainer approach specific for contractor resources. So we do advise our contractors what are the behaviors that we expect, and then we monitor that the training is completed. In terms of the specifics of the training curriculum itself, I'm not able to speak to the question, the specifics of contractor training.
Yeah, I didn't mean to put you on the spot. I just didn't know if you had anything else to add. There's certainly nothing that Charter is trying to hide here. Training our employees and contractors that are going into customers' homes is of utmost importance to us. We were trying to be responsive to the nature of the question, which was for a narrative overview.
All right, thank you. Would you like to proceed with further questioning, Attorney Cohen?
I will move on. LFE 18. You want to pull that up? Mr. Falk, I guess this one's for you.
Yes, sir.
Mr. Falk, you were the responsible witness to the response provided to the Rhode Island. If it's okay if I call them DPUC, so I don't have to go through their whole formal name. Provided to the Rhode Island DPUC data requests.
It harkens back
RI Div 1-7
in Connecticut, right, Attorney Cohen?
Yeah, but I just want to make sure that you adopted it in Rhode Island as your testimony, or you were the responsible witness.
No, I mean
because it is a Rhode Island document. Let me rephrase the question.
I was talking about calling it the DPUC. Is harkening back to another time in Connecticut was my point.
Yeah. Oh, okay.
Yeah.
Thank you. Got it. So you adopted that.
Remember when we call it the DPUC, right?
Yeah, that's what it is, but we're not that anymore here.
Right, exactly.
Yeah. Did you adopt that as part of your 1-7 as part of your testimony there? I'm not sure what their rules are. And what I'm coming to is, are there any changes to that data request document since its submission to the Rhode Island DPUC?
No, there weren't.
Okay.
I believe yes, I was asked at the hearing to adopt my responses to the DPUC discovery request.
Okay. Let's go to that actual document, which I think you labeled as Exhibit LFE 18. I guess it's page 14 of what the original filing was with the Rhode Island DPUC. If you could go to page 14, the top of that page. Would you just read or reread for yourself? You can read it out loud if you want to. The first sentence in that full sentence in that carryover paragraph. And let me know when you're ready.
This obligation to pledge extends beyond the parties who initially entered the agreement, applies to the assets of newly acquired subsidiaries. That's it.
Yeah, that's the one. So in that case, the newly acquired subsidiaries that are being referred to there, would that be Coxcom LLC?
Yes. I mean, it could mean others as well. I'm not sure that this was specifically referencing, just that, but that's the general policy, and it would apply to Coxcom LLC.
Okay. And the part of the sentence that says that the security interest in such asset extends beyond the parties who initially entered the agreement. Who would those parties be who initially entered the agreement, sir?
Again, I think Mr. Murphy might be more of an expert on this, but this is existing agreements that we have to finance debt, and it's referring to updates that may be made to those agreements as a result of acquiring additional subsidiaries through the transaction. So we have existing debt agreements that require us to pledge assets of subsidiaries. And I think what that is referencing is those agreements contemplate that additional subsidiaries that met certain criteria would be required to pledge its assets as well in those collateral agreements. Mr. Murphy, is there anything beyond, is that correct? And is there anything that you would want to add beyond that?
I think that's a fine summary. The way I would interpret the initial parties would be Charter Communications Operating and certain Time Warner subsidiaries that had existing notes, that those facilities were put in place at the time of the acquisition back in 2016 and then have been amended since that time.
Okay. Thank you, Mr. Murphy, and thank you, Mr. Falk. Probably going back to one of the earlier exhibits to the application, the corporate flow chart, organizational chart. Yeah. Charter Communications Operating is an LLC that's under Charter Communications Inc. Is that my understanding? That's my understanding. Is that?
That's correct. There are a number of intermediate holding companies, but yes, that's the chain of custody.
And in the assets of the operating companies, at least in Connecticut, perhaps in Rhode Island as well, but we only care about Connecticut here. They would fall under Charter Communications Operating, as I recall. Is that correct?
Yes, I think the way to think about it is substantially all of our operating businesses exist underneath CCO.
Okay. Thank you. Whether it's Mr. Falk or Mr. Murphy, answer the next question. I don't have any preference, but I want to bring your attention to, on the same page, to footnote 10, that has to do with documents that were filed with the Securities and Exchange Commission, one being an indenture between various charter operations and Bank of New York Mellon, and one between various charter operations. I forget if it was the Bank of America or Bank of New York Mellon. Are all those documents that are referenced in there, do they all pertain to the financing arrangements that we're talking about with respect to requiring the pledge of assets of operating companies as a condition for the financing, certain financing arrangements the charter has?
Commissioner, I'm going to object to the line of questions on relevance grounds. The request for the late file was to provide a copy of the Rhode Island filing. As indicated in the response, the law in Rhode Island is different. That's why the information was provided there and was not provided here. Charter's position is that it has no applicability with regard to this proceeding because under Connecticut statutes.
All right, Attorney Cohen, can you explain the relevance of this to this proceeding?
Absolutely. Thank you. The relevance of this is that a pledge of assets of public service companies in Connecticut requires the prior approval of this authority under Connecticut General Statute 16-43, specifically subsection A. That is the relevance. It is a jurisdictional issue. If Charter wishes to contest that, they have every right to do so, but we read the statute very differently. In our review of the case law prior to this is that pledge of assets of public service companies, including cable companies and telecommunications providers that are public service companies, all fall within 1643. So therefore, it is extremely relevant. And again, I go back to my original response to my good friend Attorney Bogan, and that is, these are late filed exhibits. It's a late filed exhibit hearing. We have a right to ask questions about the late filed exhibit. In this particular case, we need to know what these footnotes are referring to, which documents. And that is the question that was posed to these two witnesses.
May I respond?
Yes, you may.
Attorney Cohen himself said this is their interpretation of the statute. I respectfully disagree. Charter doesn't believe that 1643 is applicable, and therefore this line of questions is irrelevant. If there is a desire, we are certainly happy to brief the issue, but it's not a proper subject.
I think this will be properly addressed in brief. So if we could move on, please.
I'm sorry, Your Honor. I respect you entirely, but getting the answer to this question is integral. I asked the question about turning over this entire document into the public domain so that both the OCC, the authority, and the public could know what the pledging of assets were, which assets were being pledged. This appears to be a public document. And if they are public documents that are the financing agreements, the motion for protective order falls. So therefore, I respectfully—
I think we did have the discussion that Rhode Island law and Connecticut law are not identical. I did indicate with regard to the motion on the protective order, I would make a ruling. I'd take this under advisement. So I think at this point, if we could move on, Attorney Cohen.
Okay, let's look at the beginning of LFE 18. I want to read the second sentence. No, hold on. Stop for a second. I guess I'm going to ask the question directly, Mr. Falk. Is it the formal position of Charter Communications, Inc. that the pledge of assets of public service companies, which include holders of CCFAs, are not subject to prior approval requirements under Connecticut General Statute 1643?
Objection. That calls for a legal conclusion.
Sustained.
No, it did not. Excuse me, Your Honor. I asked if that's the formal position of Charter Communications. I did not ask for a legal opinion. And by the way, there were plenty of legal representations made in what's called the preliminary part of LFE 18. So I respectfully request reconsideration of that ruling, Your Honor.
Will you restate your request, please, Attorney Cohen?
I just asked, is it the formal position of Charter Communications, Inc. that the pledge of assets of public service companies in Connecticut, which includes holders of certificates of cable franchise authority, are not subject to the prior approval requirements under 1643?
I maintain the objection.
I will maintain, because in my view, it is asking for a legal opinion. And I don't know that Mr. Falk or any of the other charter applicants are in a position to provide an answer to your question.
I'll come at it. Well, I think I'll let it rest. I think we do have two. We did have two issues that would be proprietary that we were going to ask questions on, but we may not need to do that. I'll consult with our team at the end of the proceeding, and we'll let you know, Attorney Cheeseman. Ms. Cheeseman, excuse me.
All right. Thank you. Thank you, Attorney Cohen. Has this concluded the questioning from the Office of Consumer Counsel at this point?
It has.
All right. Thank you. All right. Is there any redirect? Or do we wish to wait till the end? Attorney Bogan and Attorney Bester.
As far as charter is concerned, we would defer at this time, maybe upon conclusion of the Attorney General or staff. We can take a break and I can visit with my clients.
All right, sounds good. Attorney Bester?
It's the same answer. We have no redirect at this time, but we would reserve the right to.
All right, thank you.
Oh, Commissioner Cheeseman, I believe you're on mute.
Thank you for reminding me. Thank you. We now have Office of the Attorney General. Attorney McCormick, are you joined by Attorney Wright today?
Yes, I am.
All right. If you would like to proceed with your cross-examination.
Excellent. Thank you. Good morning. Caroline McCormick on behalf of the Attorney General's Office. Just as a precursor and for the clarity of the record, the questions I will be asking will only reference the publicly filed, late filed exhibits. Nothing that is protected. First, I would like to start with some privacy and cybersecurity questions. Charter and Cox, this is for both of the companies. I would first like to reference late filed exhibit 22. And I would ask both of the companies to flip to that and let me know when you are there.
Attorney McCormick, just for clarification, I believe the Cox version of that is late file exhibit 20. I want to make sure we're all on the same page.
Yes. Thank you so much.
No problem.
Yes, I'm on late file 22.
Excellent. Thank you. As a condition of approval of the merger, would you agree to provide an update or statement on the integration plan on the docket 90 days after the merger closes, presuming that the merger is approved?
I'm going to object only in as much as I maintain the same objection with Attorney Cohen. The company's commitments are set forth in its application. If the authority in its infinite wisdom chose to impose additional commitments such as that which is being suggested by Attorney McCormick, certainly the company would comply.
I'll sustain that objection for the time being with the proviso, as Attorney Bogan stated. We will obviously, when preparing our decision, take into account suggestions and other information presented by people involved in these hearings.
Thank you. Now, still with Charter and Cox, referencing those same late filed exhibits. If the merger is approved, would you agree to provide an updated statement or information 90 days following the close of the transaction regarding any plans for running data impact protection assessments pursuant to Section 42.522 of the CTDPA, as well as a narrative explanation for any of the data protection assessments pursuant to that section of the statute that Charter, CEI, and Cox have run since July of 2023 through the close of the merger?
I'm sorry, Attorney McCormick, there's a lot to unpack there.
Yes.
Can you repeat the question, please?
Yes. Yes. So if the merger is approved, would the applicants agree to provide an updated statement 90 days following the close of the transaction of any plans for running data impact protection assessments run pursuant to Section 42.522 of the CTDPA? Is the first part of the question.
I think it's the same objection.
Same objection.
With the company is committed to those items that are set forth in its application. If the authority chose to impose additional requirements, the company would comply.
And I will sustain for the same reason stated before.
Understood. I would like to move on from data privacy and cybersecurity questions. And I would next like to reference late filed exhibit 26. And this is for Charter, not for Cox. Mr. Fox, could you please turn to late filed exhibit 26 and let me know when you are there.
Yes, I'm there.
Thank you. Now, looking down to the fourth paragraph of the response, do you see, as noted in Charter's responses, that Charter's responses to OCC 85 and OCC 86 and depicted on the sample bills in OCC 87, Charter itemizes the line items?
Yes. I mean, I don't have 85 and 86 open. If you'd like me to, I can, but I note the reference there in the response, and I'm familiar with it.
Okay, thank you. I would actually like you to open OCC 87 as it's referenced in that response. Oh, excuse me, actually. I apologize, Mr. Falk. Just 1 second. I want to make sure I'm directing you to the correct page. Perfect. Yes, OCC 87.
Yeah, which has a number of subparts, correct?
Yes, thank you. Would you be, can you please flip to Exhibit G?
G. Okay.
Yes. And can you please flip to the second page of Exhibit G? That says page 2 of 2 at the top.
Okay.
About halfway through down the page, do you see other charges and the broadcast TV surcharge?
Other on
It
the
should
right
be
side or the left-hand side?
the left-hand side.
I see something that says broadcast TV surcharge, payment processing, other charges total. Is that what you're asking me?
Yes.
Okay. Yep.
Now, clicking into or referencing back to late filed Exhibit 26, in the second paragraph, there was a website provided, spectrum.net/taxes and fees. And that website also included the fees/surcharges. The second option down is the broadcast TV surcharge. Now, with this as background, I'd like to ask, why was the broadcast TV surcharge not included as a response to LFE 26?
If I may, Ms. McCormick, I think the answer to your question is contained in the footnote 2, where it says the surcharge is not responsive to the LFE request.
Because it is subject to prior customer notification. Now, in looking at the bill, and in looking at the fee/surcharges sections, I do not see any separate customer notification. Mr. Falk, how would customers receive notification about an increase in the broadcast surcharge?
They'd likely receive it in the, I mean, Ms. Kim could probably answer better than me, but typically information like that is provided in the, the notes section. For example, on page 2, the information that's contained on the right-hand side of the page.
That is correct.
We
The
often
notification.
we provide that information as I mean, these are typically called bill messages. And so in the bill message section is where we would provide that information to the customer.
Yes, with 30 days advance notice in the bill statement.
And now this bill that was provided as OCC 87 Exhibit G, is that currently what bills look like for customers post the FCC rule that requires that broadcast TV surcharges be included in the upfront advertised price?
Well, the bills we give to customers change on a monthly basis, depending on the services that they receive, depending on the applicable bill messages for that particular month. So this was a sample bill as of the time that it was provided to a customer.
Understood. Now, specifically, would the broadcast TV surcharge, does that still exist broken out on page 2 of the bills as it appears here?
I mean, if I may, Commissioner, Ms. Kim has testified that the customers receive notice of any change in the billing elements, including the broadcast surcharge, 30 days in advance of it happening.
Commissioner Cheeser.
Yes, I've unmuted myself. Can you restate your question possibly in a different way?
Yes. Will customers continue to see the broadcast TV surcharge broken out as it is on page 2 of this bill?
If I may, Commissioner, the question was when the late file request asked about surcharges. In the footnote, it indicates that these and I think I recall it was in the context of surcharges that for which customers would get notice or would not get notice. The broadcast surcharge is not an element for which customers would not get notice. They get notice when it happens. It may not be broken out as a separate billing element. I'm sure there are other cost elements that are not, but they are included in the customer's bill and they get notice of it.
Does that satisfy you, Attorney McCormick?
Yes, that does.
Can I just also ask that Attorney McCormick look at OCC 97? Maybe this is clarifying the question that she's asking, which is that for legacy cable TV service packages, it's assessed and itemized on the statement, which reflects the charges from the broadcast TV affiliate stations. For cable service packages offered after September 17th, when the FCC's rules went into effect, those costs are included in the promotional and standard rates. Is that what you're getting at, what you're asking me? Because I'm trying to be responsive and address your concern. I appreciate Attorney Bogan's objections. I think we're answering the questions, but that seems to be what you are trying to assess. I think it's already been asked and answered.
Thank you, Mr. Bach. Huh? Now, to understand how the broadcast TV surcharge as it exists in Connecticut versus the rest of the country, are Connecticut costs higher when establishing the broadcast charge than other states? My understanding is that in other states, the broadcast charge stays the same throughout the country and on different levels of bills. But does it cost?
I apologize, Commissioner. I certainly don't want to speak more than Mr. Falk today, but clearly that question goes beyond the scope of this late file exhibit.
Can you explain the relevance, Attorney Cormick, of this question to this particular hearing?
Yes. So what I'm looking to establish is if this broadcast TV surcharge is something that Connecticut is, if these are aggregated costs nationally, and if the surcharge is unfairly penalizing Connecticut customers, if we don't cost as much compared to states, different states in the country, if everyone comes out about the same, and the surcharge is about the same, then the level of concern isn't there. But if Connecticut costs less and other states cost more, and everyone is paying the same amount, that's my area of concern.
May I respond?
Quickly, and then I will make my rules.
Yeah. I mean, the late file requested a list of all taxes, fees, and charges. It didn't look for any sort of comparison with regard to other states, number one. Number two, the suggestion that Connecticut customers might be unfairly penalized simply ignores the reality of the competitive market. If you raise your prices too high, customers will vote with their feet. That's all I have to say.
All right. I think we'll allow this line of questioning. So if Mr. Falk would like to respond.
First, the thing I would say is that we answered the question in the prior hearing, indicating that the broadcast TV surcharge was set at a national level, not on a regional basis. So that question was asked and answered. As I said, I don't see any relevance to this line of questioning because, as Attorney Bogan just said, our rates have been recognized at the national and state level to be deregulated because of the competitive nature of the market. Our rates and how we calculate those rates aren't a subject of this hearing, nor are they relevant in any way because there are many choices that consumers have with regard to where they get their services. And if customers are unhappy with the cost of our service or happier with the cost of someone else's, they certainly have a right to seek out those services. We offer competitive services, pricing to our customers. As we stated previously, we have worked really hard as a company to add value to our cable television packages. One of the ways we've done that is by being the company that took a stand and said we are not going to continue with these programming relationships where the streaming services that these content providers are offering would not be available or would only be available to our customers at an additional charge. We took that position on behalf of the entirety of the industry. And as a result of it today, customers who take our services can get up to $125 in value from the streaming packages that we offer associated with those underlying services for free.
All right, thank you. And I think Attorney McCormick, the parties have established where they stand on this. I don't think we're going to benefit any further from more lengthy discussion. So if you could move on with your questioning, please.
Thank you, Commissioner Cheeseman. That was the end of my questioning.
All right. Does Attorney Wright have further questions for our witnesses?
No, thank you, Commissioner. I apologize for no video.
All right. It happens to all of us. All right. I believe that brings us to Pura staff for questioning of our witnesses.
Yes, Commissioner, I just have a couple of short questions for Charter and Cox.
Please
Also,
proceed.
sorry. We have the answer to the previously requested read-in if you would like it now, or we can do it. We can do it.
Are you happy if we quickly get this in, Attorney Coker?
Yes, that's fine.
All right.
Mr. Stamp, are you prepared with the read-in?
Yeah, just to close the loop, the contractor or the training related to working in the home applies both to our contractors and our in-house employees, as stated in the response.
All right. Thank you.
Thank you, Mr. Stamp.
Thank you. All right. If you could proceed, Attorney Coker.
Thank you, Commissioner Cheeseman. Good morning to everyone. I'm Pure Staff Attorney Josh Coker. To start with, to the representatives for Charter and Cox, please turn to the responses to LFE 7 and 8. So these responses indicate that all contractors complete a background check. Are those results of those background checks retained by Charter and Cox?
The background checks of the contractors or our employees?
Both.
I'm certain that there are document retention requirements that apply to the information. So yes, they're retained. I don't know the length of document retention requirements, that exist under applicable law. So I can't tell you how long they're retained for, but I'm sure that information is retained for an appropriate period.
Is there a difference in the retention policy for contractors and employees?
I don't know. I we're required to follow the law, whatever the law is. I don't know offhand what the document retention requirements are.
Thank you. Does Cox have anything you would like to add?
No, I think my response would be the same as Mr. Falk's. I'm sure we keep them, and even as to the contractors, right? I don't know if the contractor keeps them on their own employees or somehow turns them over to us. So but again, I think it's fair to say we follow the law and do what we need to.
With what you know of your document retention policies, are documents such as background checks or other initial employment documents retained in a central location, for example, at like one of the headquarters, or are they retained on the site that's hiring the employee? Is it centralized or decentralized?
I don't know the answer to that.
Does Charter track and similarly track and retain employment related legal claims, settlements, or regulatory policies involving its contractors or workforce?
I'm certain we do.
Do you know if that is retained in a central location or decentralized? Where is that type of information kept?
It wouldn't be kept on a decentralized basis. It would be centralized, whether it's centralized in Connecticut or in, for example, Missouri, St. Louis, where much of our legal documentation is held. I couldn't tell you for sure, but we have centralized locations, and much of our legal documentation records are kept in St. Louis.
But you don't have that information available right now.
I don't. No.
Understood. That's all the questions I have.
All right. Thank you, Attorney Coker. Are there any further questions from Pura staff?
Not to my
Commissioner
knowledge.
I'm sorry. Yeah.
Sorry,
No cross, Commissioner Cheeseman. Thank you.
All right. Thank you. All right. Are there any redirect?
Yes, Commissioner, if we could take, I would normally say 5 minutes, but can we take 15
yes.
minutes
do
till
you want-
11:30 so that we can figure out how we confer?
Sure. We will stand in recess until 11.
Your Honor, before we break, the OCC will have a few questions proprietary that we can do after the redirect.
We will take that under advisement, Attorney Cohen.
We have to do it, Your Honor, and unfortunately, the company has filed things under protective order that clearly, from our perspective, do not deserve to be kept out of the public domain and should be able to be relied on by the commissioner, and members of the public should be able to see it.
So
Thank you.
you would like to go into private session?
That is correct. That's the only option, unless the companies are willing to orally remove the request for protective status for LFE 18, and they'll probably have to discuss that during the break.
All right. Well, let's break and reconvene at 11:30, please.
Thank you.
doesn't seem like they are making any progress with these issues with the commission. So I don't have. Okay, Tom, can you go on mute? So I don't have to. Sorry.
Tom, just letting you know that you are unmuted on the Zoom call.
Oh, got it. I'll do that.
All right. It is 11:31 and I am going to reconvene this late filed exhibit hearing. We are going to take redirect and then we are going to open a closed session for discussion of a protective order. After the redirect, I will explain the procedure. So if we could
Yeah.
go
I'm
for.
sorry, Commissioner, in talking with my colleagues, we are going to try to, with your permission, we are going to try to ask questions in a way that are within the scope of, don't get so far into the confidential materials, or the alleged confidential materials. So, and then if there are objections, then we can go into
All right. Well,
proprietary.
obviously, it would be ideal if those are the circumstances and your questions can be answered or to the best of the party's ability under those circumstances. But if necessary, we will go into closed session.
Thank you. We're trying to accommodate and make things easier for
All
the
right.
employee.
All right.
If I may have 1 second, Commissioner.
Yes, please.
We don't have authority yet.
You're on mute, Attorney.
Okay, thank you. That's it. Appreciate the indulgence. If Attorney Cohen wants to proceed, that's fine.
So, Cox and Charter, would you prefer that OCC goes before the redirect, or do you wish to do the redirect now?
It certainly seems to make more sense to finish the cross-examination, and then we can do redirect if we have any.
All right. And Cox, you're happy with that as well?
Yes, that works for us.
Attorney, all right. All right. Attorney Cohen, if you would like to proceed.
Thank you, Your Honor. Again, we're talking about LFE 18 and the pledging of assets, Cox assets. Is my understanding correct that certain types of entities that are not required to pledge their assets pursuant to these financing arrangements that we're talking about in LFE 18? Is that possible?
Yes,
I'm sorry, I didn't hear that.
yes.
I didn't. Who answered that? I didn't. Was Adam, was that you?
That was Mr. Falk, and he answered in the affirmative.
Okay. Thank you. Okay.
I mean, yes, yes.
Thank you. And is it, so is it possible, let's just assume for hypothetical situation, that there's no requirement, you take that position that there's no requirement to pledge assets, and Pura issued a decision that says you cannot include Coxcom LLC's assets in Connecticut without without prior approval. Is it possible then to exclude the Connecticut assets of Coxcom LLC under the financing arrangement?
I'm trying to work with Mr. Cohen, and I appreciate that he's trying to do the same, but the witness is not here to respond to hypotheticals.
I would sustain that objection.
Okay, I'll rephrase it. Can Charter, which has these financing arrangements, designate the Connecticut assets of Coxcom LLC not to be pledged under the terms of the financing documents?
I'm sorry, can you repeat the question?
Sure. Can you deem you're not required to pledge all your assets under the financing documents? can you include the assets of Coxcom LLC in Connecticut to be excluded under under your financing arrangements?
So without getting too deep into the confidential information and designations, I think the relevant part I can share, which is that there is a de minimis subsidiary allowance for exclusion. And so that can be used. Coxcom LLC is a subsidiary that my understanding is holds significant assets beyond simply the assets in Connecticut. Does that answer your question?
Sure. So I believe it partially does, Mr. Falk, but I guess the question is, can you split off the assets of Coxcom LLC in Connecticut?
That's a hypothetical that I couldn't answer for you today.
Okay. Let me just check my notes here. Your Honor, I have no further questions. Thank you, Mr. Falk.
Well,
Thank you. Thank you, Attorney Cohen. Now, is there any redirect?
1 second. I have no redirect, Commissioner.
Attorney Bestor?
Cox also does not have redirect.
Right.
I'm sorry, Commissioner Cheeseman. It's not a redirect, but I think it's worth adding a response to a question that was asked before that I didn't have information on, which relates to the recertification of the background checks for our contract employees. We do recertify those on an annual basis, and so in the interest of not messing up your procedure, I thought it would be helpful to.
I think it's helpful to address questions that were not answered earlier, even if we're technically not doing it at the right time. But you'll give me some leeway because this is, as you will know, my first late file exhibit hearing. So anyway, if there are are there any administrative matters that we have to address before we adjourn?
No, Commissioner. Thank you.
Anyone?
None from Cox.
All right, last call. I believe the next deadline, close of record today at 5 p.m. with briefs due on December 12th. And I want to thank everyone for their participation today. And I will, without further objection, adjourn this late filed exhibit.
One clarification. I believe you said briefs due December 12th. The schedule notes December 22nd.
Oh, right. I may not have an updated
I have the 22nd
schedule
as well.
here.
Thank you.
All right. Any further comment, questions, clarifications? I will hereby declare this late filed exhibit hearing